I'm going to join too.
Good afternoon, everybody, and welcome to another instalment of Napthens in-house council network updates. These are updates which are specifically targeted at in-house lawyers, in-house counsel, and HR professionals. Just to let you know that the session is being recorded, and we will be circulating a full recording with the slides to everyone who has registered. So that's something that you can listen to later on, along with your favourite podcast. Today, we are going to be covering three topics. Firstly, I'm going to be having a look at the soon-to-be implemented Data Use and Access Bill, which is the latest instalment in the series of changes or proposed changes to GDPR. Which have been in the pipeline. Then my colleague Rachel Atherton will be taking us through some key cases that have happened in the area of commercial law in the past 18 months. And then after that, to round up, my After Athena colleague, Sophie Fulwell, will be taking us through the large topic of the Employment Rights Act, which is probably the biggest change to employment law in a generation. So we have quite a lot to cover. If you do have any questions, given the breadth of the subjects we're going through, please do pop them in the chat. And if we don't have time to cover them at the end, we will try to, then we will get back to you individually and try and give you a satisfactory answer. Thank you. Next slide. So I thought it'd be useful primarily to sit the new bill in its context. I think many of us will remember the painful process and very large compliance burden of the implementation of GDPR in May 2018. This was a big change to data protection law, and has really set the basis of our current data protection law, probably for the next 20 years or so, if we're speculating. Now, one of the questions that I guess many of us will have been repeatedly asked at the time by frustrated colleagues was, well, if we're about to Brexit, why are we going through this very painful and burdensome compliance exercise? And the answer to that was always that there was absolutely no appetite from the government back in 2018, or indeed now, to prejudice the UK's data adequacy. So it was a priority for the government to ensure that data flows were passing easily between the UK and continental Europe. So as a consequence, GDPR was adopted without any changes, and that priority of complying with data adequacy requirements of the EU has underpinned really all changes and the approaches of the two governments since. You'll see that in January 1st, 21, when we exited, there was a minor change with the introduction of the UK GDPR, the standalone version, but that really was just a series of changes to make the Act work, to make GDPR work on its own basis. There were no real changes at that point to the substance of the law. Next slide, please. Based on that approach, and to the government's great relief, the UK was granted data adequacy status in 2021, very shortly after we'd left. But following on from that, and in line with the then government's deregulation agenda, a new bill was introduced in 2022 to try and make certain changes to GDPR. This was the Data Protection and Digital Information Bill. Although it was trumpeted as a significant deregulatory measure, I think an independent observer would have to agree that because of the need to keep to the adequacy requirements, the changes were probably not great. Some of them were significant, and we'll have a quick look at them later. And some of them were indeed quite popular with industry. But that bill fell in total when Rishi Sunak prorogued Parliament in 2024. So it's gone. It's of historical interest only. The current government came in with its own ideas, and it has introduced the Data Use and Access Bill, which is the one we are going to look at now. New slide, please. And whereabouts are we in relation to the Data Use and Access Bill? Well, it's almost on the point of being finalised. It's almost on the point of getting royal assent. The third reading was passed at the beginning of this month. There are one or two very small amendments bouncing about between Commons and Lords in relation to AI, which it deals with. But these are expected to be resolved imminently, and royal assent we should expect within weeks, with the main provisions then coming in 2026. Well, what should we expect from these provisions? New slide, please. I won't take you through all that small print. That is the introduction to the bill. But if you do have time to look at that and you look at the highlighted version, you'll see that it really is mostly about data protection. you can see there, to make provision about the keeping and maintenance of registers of births, the regulation and processing of information, etc. It deals with one or two things that have just been thrown in there for convenience, but is primarily a bill that deals with personal data. Next slide, please. There are eight parts. Access to customer and business data, digital verification services. As I mentioned, this is the odd sort of rag bag of things that have been thrown in. So we've got a reference to the National Underground Asset Register, which we won't be talking about. But you'll see with the rest as well, parts 4 and 5, 6, 7 and 8, they all relate to data protection issues. And I will, other than the National Underground Asset Register, which I won't spend any time on today, I will deal with them all briefly as we progress. Next slide, please. As I mentioned briefly, there were some, albeit fairly minor, but quite popular suggestions in the Tory bill, which have now fallen by the wayside. So if you have announced these or briefed these out within your organisations, unfortunately, these are gone. These include the proposal to, in some circumstances, to replace data protection officers with the lesser and more relaxed version of senior responsible individual, and also the relaxation of the requirement for data protection impact assessments. That was a popular suggestion because they're obviously quite burdensome, together with some other provisions on data subject access requests, and when controllers have the right to not to respond to those. But unfortunately, those are all gone. Again, historical interest only. So let's look at the key provisions of the current bill. Next slide, please. Legitimate interests, there's some change to that. Legitimate interests are obviously very important because we have been relying on those, in particular in relation to lots of areas like direct marketing. The government has helped by giving clarity here, by giving a list of specific areas which qualify as legitimate interest, and then happily they've got direct marketing in there, together with intergroup administration and various other things like security of systems. So that's very helpful. Significantly, they have also introduced a whole new lawful ground, which is recognised legitimate interests. These apply. For these, you don't have to apply the normal balancing test. So you don't have to weigh up the rights of the controller against the rights and freedoms of the individual. They are predominantly going to apply to public sector organisations. As you can see there, they apply to national security, defence, etc. But there will be some areas where they do apply, particularly, for example, in relation to safeguarding vulnerable people, where there had been some cases, for example, of utility companies not feeling comfortable disclosing information. So that should apply in those kind of situations. New slide, please. There's a new complaints process which has been brought in. Currently, as many of us will be painfully aware, complainants can go straight to the Information Commissioner. Well, they can't anymore. They now have to take their complaint directly to the controller before they can go on to the Information Commissioner. What that means is, I guess, in terms of changes, that organisations are going to need to have policies in place and complaints procedures so that to make sure that these are properly dealt with. And it's also going to have to be tracked in privacy notices too, so that individuals are told what processes they must follow. So there will be some updating needed there. In relation to data subject access requests, the changes are not as significant as previously, but some of them are helpful nonetheless. There is a constant question that comes up of how much searching should be done, particularly, for example, in relation to large amounts of emails. Well, it's now been codified that searches should be reasonable and proportionate. That effectively adopts the ICO's current guidance, but it is helpful nonetheless, although I expect that there will be some challenges to that particular that particular wording and where that line particularly should be drawn. Next slide, please. From an administrative perspective, a decision has been made to restructure the Information Commissioner, the Information Commissioner's office. Currently, the Information Commissioner is an individual, Mr. John Edwards. Well, that's changing. He's becoming the chair of a new Information Commission. It will effectively have the same powers. But it will be useful to know, particularly where we're giving references, for example, say in privacy notices, etc., and in our dealings with the Information Commission. There are some significant changes in relation to cookies. I'm sure everyone is painfully aware of how impractical the current regulations have been, with the requirement for consent to be given to virtually all cookies. Well, that is being relaxed slightly. So for statistical performance cookies, etc., there is now no need to get specific consent, explicit consent. So that should make the process easier, with less annoying pop-ups appearing. Hopefully something to run past your IT departments once we have the guidance in place. So that should make the process less burdensome. Also worth noting that PECA, the electronic communications regulations, which are a separate piece of regulation to GDPR and the Data Protection Act, there has been this issue where there's been a gap in fines and the ability of the regulator to fine. Previously, that was capped at £500,000, and as that covered electronic data direct marketing, that was an issue. So, unhappily, I think for compliance departments, I think we have to be aware that that has now gone up to the general GDPR-based limit of £17.5 million, or 4% of global annual turnover. So a very significant, potentially a very significant amount. New slide, please. Automatic decision making. This again comes out of the government's agenda to drive AI. At the moment, decisions based on AI are very tightly restricted. Effectively, they can only be done in connection with entering into a contract. So, for example, credit checks, and also by consent. Well, that again, that's being relaxed. So there'll be much more decision making that can be done automatically by AI, with some carve-outs, significantly for sensitive personal data. But there are restrictions, as you'd expect, so the individual has to be told about it, and there has to be a right to demand human intervention if the person is unhappy with the decision that's being made. But again, could well be a significant change. Next slide, please. And then just to finish off, international transfers, as you may be aware, before data can be transferred out of the UK to a jurisdiction that's not had an adequacy judgment, the controller technically has to carry out its own assessment of the foreign jurisdiction. So if you're transferring personal data, say to India, to Nepal, etc., there's an obligation on the controller to carry out their own assessment. That currently is the old GDPR requirement, which is to ensure that the local regulations are not materially lower are essentially equivalent to GDPR. That is being changed to not materially lower. So the assumption is that that will be, again, a relaxation, and it will be easier for controllers when they are conducting what is actually quite a difficult exercise. It will be easier for them to sign off on that. And then just finally, we have two significant introductions of what are essentially legal frameworks from which we'll see more regulations arising. These are in relation to smart data schemes. Currently, that's the government's been very impressed by the open banking requirements, which are in place, which allow people to swap banking providers easily, and this is done by regulating the third parties themselves, the commercial providers running schemes and getting trust marks in place, and they're looking in effect to expand that on a statutory basis to other fields, like, for example, energy. So it would be easier for individuals to swap from one provider to another. And also, you may have heard, so there's been some reporting on it as well in relation to digital identities. And again, the idea is to create a framework for third-party providers who will certify digital identities. So the old idea of turning up with a paper gas bill, which is obviously seen as being very unsatisfactory, that will fall away, and that there will be digital ID verifiers and a statutory scheme for that. Okay, that's a very quick overview of what is quite a significant and we think will be quite an interesting new piece of legislation. So if you do have any questions, as I say, please do let me know. And when we get the final bill, which, as I say, we're expecting imminently, we will do a further update on that, and we will let you know about that. So at that stage, if I could hand over to my colleague, Rachel Atherton, who will take us through some recent developments in the field of commercial law. Rachel.
Thanks, John. Hi, everybody, and thanks for joining us for this update. I'm just going to go through some contracts and some points that came out of them, some contract cases. I spend a lot of my time drafting and reviewing commercial contracts, so it's always good to keep up with the latest case law. Could I have the next slide, please? So these are the areas that the cases are going to cover: third-party rights, force majeure, and particularly reasonable endeavours when it's used in that clause, which often is, waiver, penalty clauses, and a few cases on limiting liability as well. Could I have the next slide, please? Okay, so the very first case that I'm going to talk about is a Supreme Court case which talks about third-party rights, and this was a claim brought by the Public Commercial Services Union against DEFRA. Obviously the judgment is long, but the facts of the case were that there was a clause in the contract between the employees of DEFRA and DEFRA, which provided that DEFRA was going to deduct union subscriptions directly out of their salary and pay it straight to the union. And this was called a check-off clause. But DEFRA decided it was going to stop making these payments in breach of the clause. Because it thought, why should we provide this service, essentially? And obviously the Public Commercial Services Union wasn't party to the employment contract, so it didn't have could it bring a claim as a third party or not? The employees hadn't lost anything because they had actually probably received a little more in their pay packets. So the union went out to its members, tried to get them to sign up to direct debit and so on, but it still suffered a loss of revenue. And the question was, in the end, that the Supreme Court addressed was whether or not the union could enforce these check-off clauses under the Contracts Rights of Third Parties Act 1999. So the Supreme Court went through, the background to the act and one thing and another, which has obviously been in place for a little while. And so just to remind everybody what it says, I know these are kind of standard boilerplate terms, obviously, aren't they, dealing with rights of third parties? But anyway, this is what the Act says. It says, subject to the provisions of this Act, a person who is not a party to the contract, a third party, may in his own right enforce the term of the contract if the contract expressly provides that he may. Well, that didn't apply in this agreement. Subject to subsection 2, the term purports to confer a benefit on him. Oh, somebody's joining. So in this case, clearly the term of the contract conferred a benefit on the third party. But the question was that defeated by subsection 2, which says this subsection does not apply if on a proper construction of the contract it appears that the parties did not intend the term to be enforceable by the third party. So it had met all the tests. There was a benefit conferred. It was identified in the contract. Question is, did the parties intend for the presumption not to apply? And the Supreme Court gave some useful guidance and says, if a term does confirm a benefit on a third party, then there is a strong presumption that the beneficiary can rely on that term in its own right. And that would only be rebutted by express words. Now, so the union was able to make the claim. I think this is a useful one to remember when we're drafting contracts, especially when they go back and forth in negotiation. Often we have this kind of wording which says, unless there's anything to the contrary, then the Contract Rights of Third Parties Act doesn't apply. I think in my contracts from now on, I'll be really thinking this through, because I'll probably want it to be really definite. This contract does not apply. It cannot be enforced by third parties. Probably be more definite about it, especially actually when you're dealing with contracts which allow the affiliates of the customer to take advantage of the benefits of the contract. So quite often you'll have these kind of fairly shortcut framework agreements where, the services or goods can be ordered or provided to affiliates of the customer. There's no query there, like, who is going to bring a claim if this goes wrong? Does the supplier or seller anticipate a claim from one of these third parties, or is it just a contract between two people? And to really have that out in negotiation, or at least if you're seller or supplier, to make sure that no third party can enforce against you. And if they can, what are you going to do to your liability clause just to make sure that you don't end up subject to lots of different claims that you hadn't anticipated from different parties? So that was the first one. Next slide, please. Okay, so this was a case concerning force majeure. Again, Supreme Court case. Now, there's been quite a lot of talk, hasn't there, on force majeure clauses since COVID, because clearly that was a big force majeure event, a frustrating event in lots of contracts. In this case, the MUR Shipping was the owner of some ships, and RTI agreed to charter them. And the payment was going to be made by RTI in US dollars. And it was for shipping of bauxite, several tons of bauxite to the Ukraine. And it was anticipated that there was a constant flow really of vessels on this route that would be dealt with under this agreement. It had a force majeure clause, which I think is in fairly standard terms based on what I see. So it said that no one's going to be in breach if they can't perform because there's a force majeure. And then it defined a force majeure event as an event or state of affairs which meets a number of criteria. So it's outside the immediate control of the party. Okay. It prevents or delays the loading of cargo, discharge of cargo. And it's caused by one or more acts, fairly familiar, acts of God, government, earthquakes, weather, etc. And then it also said it cannot be overcome by reasonable endeavours from the party affected. Now, in the background, RTI's parent company and thereby RTI became subject to US sanctions because of the war in Ukraine. And it wouldn't be able to now pay in US dollars, which is what it agreed to do in the contract. Now, so what happened is the ship owner, MUR, it suspended performance, says, right, we're not giving you any more vessels. We've been affected by force majeure. You can't pay us in US dollars. And RTI said, well, no, we can pay you in euros, it's fine, and we'll bear all the costs and charges associated with that. So there was no detriment to MUR. So RTI then claimed damages for the cost of replacement vessels during that suspension. So the legal issue was, could MUR, so that's the provider of the ships, suspend performance under the force majeure clause, or could actually that force majeure event the delayed payments in euros be overcome by reasonable endeavours, which would be MUR accepting payment in euros. So to me, it sounds on the face of it fairly sensible. We can't pay you in US dollars, but we'll pay you in euros. So what's the problem? But the decision was that MUR was entitled to invoke force majeure. So it wasn't obliged to accept payment in euros when the contract had stipulated that the payment should be in US dollars. So it's quite it's a point of principle, really, that you can't reasonable endeavours in a force majeure clause doesn't oblige anybody to accept performance which is different to that which is specified in the contract. So the FM clause isn't there to provide a workaround. Even if there's no detriment, the parties need to consider what constitutes performance. And if there's to be deviations from that in the event of force majeure, then fine, think about them ahead of time when you're drafting and make it clear. Because if the contract doesn't make it clear that you can do something else other than contractual performance, even if there's a force majeure and even if there's no detriment to either party, then you won't be able to get out of your contractual obligations and rely on the force majeure clause. So I think that's quite an interesting case, and probably just a word of warning. It's one of those where you're drafting your contract and you think to yourself, what could go wrong in this particular contract, and what do we agree now? Because we're the party to the contract. We can agree whatever we want, but once we've agreed it, that's what we're going to do. And even if there's a force majeure event, we won't be able to change that. Can I have the next clause, please? Not the next clause, the next slide. Okay, so the next one, this is a clause about contractual waiver, which it probably, well, you can see what you think of the facts. So there was the two parties to this agreement were an energy company and the customer of that energy company called Notting Hill Genesis. They entered into a long-term energy supply contract, which had a fairly standard clause in there on termination, which said that the provider URE Energy could terminate if there was insolvency or a solvent amalgamation, but that had been carried out without the energy provider's consent. And in these circumstances, the contract provided that they could terminate the contract and claim 50% of the remaining charges as compensation. So as it happened, Notting Hill did go through an amalgamation without the advance approval of URE, the energy company, but they knew all about it. There was no secret, there was no nothing at all to suggest that the energy company didn't know. And then 6 months later, it then decided to terminate the agreement using this clause. But the question is, 6 months have passed, you knew that we'd amalgamated, you didn't do anything about it. Have you now affirmed the contract, or have you waived your right to terminate this contract? So the court run through the exercise of termination rights in these circumstances, and it's spelled out the test, which I think is quite useful to see set out. So what it says is where a party becomes entitled to terminate, it must elect whether to exercise the right or not. Fine. It must be aware of the facts giving rise to the right to terminate and of the right itself. So clearly it was aware of the right to terminate, but was it sorry, it was aware of the facts giving rise to it, i.e. there'd been an amalgamation, but was it also aware of its right to terminate? Had it effectively read its own agreement properly? And that's where the claim fell down, because what they found on the facts is that actually URE hadn't waived its right to terminate because it wasn't aware of its termination rights, even though it was advised. They had Burgess Salmon as their solicitors, and even though it said so in the contract, when they looked at the evidence, it turned out that it had been a fairly quick job. The client on the client hadn't really read or been advised of the termination rights in detail, and actually he'd just seen it as boilerplate, which I think probably any of us who, when we're advising clients, sometimes, you are at pains to explain to them, exactly what the different clauses mean, but sometimes people want to get it done, and they don't always, look over every single clause with a microscope, which turned out to be a good thing in this case, because they were able to say that they hadn't waived their right to terminate. So, I mean, I reading this, it's an interesting one, isn't it? Because I certainly wouldn't want to go down the route of not bringing clauses to people's attention just in case they needed to not know what they said. Somebody's just put a question in there. Is it being appealed? I'll have a look in a minute. I'll check that out for you. Yeah, so because what had happened, so there was a presumption that they knew because it was in the contract, but actually when they looked at the evidence and they waived their right to privilege, and the file from Burgess Salmon was disclosed, and on that basis they found all the facts that they hadn't actually been aware of it. So that was where that got to. As always, if you've terminated a contract, there's going to be a balance between weighing things up properly against acting quickly enough not to have waived your rights. Can I have the next slide, please? I'm going to have to speed up, I think, a little bit looking at the time here. So this is a case on Hussein and others against London Credit Limited. It was a loan which was secured by a debenture over the lender's assets and also some property, including a family home. The interest on this agreement was 1%, 4% on default, and they found that actually in breach of the facility letter, that one of the houses of the family home had been occupied by related persons, although it turned out that everyone actually knew about this, so there was a level of it being disingenuous as well. The interesting thing on this case really is just, again, the reinforcement. I'm just looking at a question that's popped up. Sorry, I'll come back at the end, Crystal, if we've got time. So the question here is what is the test for a penalty? Well, this was obviously set out in the Cavendish and MacDessy case, and really all this case does is give us, unless you're kind of in the business of loaning money or negotiating cost orders, then probably the most interesting point out of this is just that reminder about what the test is, and reminders to the court as well to take them one step at a time, because in this case the judge hadn't directed himself properly and looked at each question. So first question, is there a secondary obligation engaged upon the breach of a primary obligation? So yeah, we were happy with this. They hadn't paid the obligation to pay the default interest had arisen because of the breach. And what was the extent and nature of the legitimate interest of LCL? And that's the person trying to impose the so-called penalty in having the primary obligation performed. Again, the judge had fallen into error. And then the final point, was that secondary obligation exorbitant or unconscionable? So just really a reminder about how high the bar is to have something judged as a penalty rather than an enforceable clause. And again, the court just confirming that for us, and that's gone back, I think, to be decided on the facts, but just an interesting reminder of where we are on penalties. Can I have the next slide, please? This one, another interesting case. So this was a case between Innovate Pharmaceuticals Limited and the University of Portsmouth. And the company engaged the university to carry out some research into some drugs. These were highly complex drugs to do with brain cancer. There's quite a lot of detail in the judgment about exactly what they did and how skilled what a skilled job it was to test them. The work was to be conducted by an employee of the university, a Dr. Richard Hill. There were the normal provisions in that agreement about the use of reasonable care, one thing and another. And there was a limitation clause saying, we're not liable for more than £1 million, save for, and one of the exceptions was fraudulent misrepresentation. Dr. Hill turns out didn't do a very good job. He published a paper which was then heavily criticised by his peers. He published corrections which were also contained inaccuracies. He was under some personal pressure. It wasn't going well for him. One way or another, he was found to have he was found to have been guilty of research misconduct on the university's own kind of methods of looking into these things. But what IPL wanted to be able to claim is that his conduct amounted to a fraudulent misrepresentation. And the upshot of this is, which may come as no surprise really when you break it down like that, there's a difference between fraud in the performance of a contract and fraudulent misrepresentation as part of the formation of the contract. With the court commenting interestingly that there was no there was no hard and fast rule that performance fraud would be not able to be excluded by a limitation clause. So as it happened, this guy, Dr. Hill, they didn't think he'd been dishonest. He'd just been very careless. But they did comment that if the clause had been drafted differently to carve out fraudulent misrepresentation and fraud, and that he'd found to have acted fraudulently, then the cap wouldn't have applied. So it's an interesting one. And they made some comments as well about, who performed the fraud. So if it's one of your employees somewhere being dishonest, causing a loss, then that probably can be excluded by an appropriately worded limitation clause, which I think is really interesting. If you're you could be in a logistics provider, someone in your warehouse does something dishonest, should your liability cap for that loss be removed or not? If you were the supplier, you probably don't want it removed. If you're the buyer, you probably definitely want it removed. So it's just one to consider. And also, again, when the contract goes back and forth being negotiated and things are starting, you might have started with one way limitation and now it's for both parties. So I suppose with all of these cases, you start from one position, you negotiate certain elements, and then probably the next step is to look at it with a cold head and think, right, okay, is this actually what we wanted, and have we thought of the main risks to cover here? So action, I've put there, just obviously negotiate an appropriate cap and make sure performance fraud is caught if you're the buyer and if you can negotiate it. Could I have the next slide, please? Okay, so this was a case between some owners of a small kind of supermarket and then cost cutter supermarkets group. It was essentially an agreement to purchase goods, although it had morphed over time from being an agreement where goods were provided and then a commission charge. It doesn't really matter. What the defendants tried to rely on is a limitation clause, which said we're not going to. They tried to argue that the wording of the limitation clause meant that they didn't have to pay for some stock that had been provided, and they tried to pick apart the limitation clause, or their counsel did, in order to kind of make this point. They weren't successful. The court said, no, there's a distinction here between your primary obligations in a contract, i.e. to pay, which was a debt claim, and for what you might recover in a damages claim. I think that it seems fairly obvious to me that that's the right answer, but it did get as far as court, so I don't think I'll be taking out of my drafting anytime soon in the exclusion clause the wording which says except for customer's obligation to pay if I'm acting for supplier or service provider, and also think about the effect on indemnities. Indemnities, you would argue, if you wanted to enforce one, are a primary contract obligation enforceable as a debt. So if you want to cap them, make sure that you've done that specifically and don't rely on an exclusion clause or limitation clause, which just says all liabilities under the agreement. Next one, please. Okay. So this agreement is one between EE Limited and Virgin Mobile Telecoms. And this is the interpretation of an exclusion clause, but it's also specifically relevant to any agreements that have exclusivity clauses in them. As many of the agreements that I deal with have an exclusivity clause, where you say, well, if you don't have an exclusivity clause, you've got no obligation to use us, so we need to have it. In this agreement, EE and Virgin Mobile entered into a network supply agreement. So EE said, right, we'll use your network exclusively But then they varied it as time went on because they needed to use a different provider for 5G. So they said, okay, if we move customers onto 5G, then those same customers can also receive 2, 3, and 4G from the new network provider. And they began to migrate customers to another provider. EE claimed for breach of contract and for revenue it would have received if the exclusivity clause hadn't been breached. Now, in the clause, there was there was a mutual exclusion for each party. Neither could claim anticipated profits. And really, the question on the contractual interpretation was whether or not EE's claim was excluded by the exclusion clause. It was a heavily negotiated agreement. They said, well, hang on, there's a separate exclusion for consequential losses and indirect losses, so they can't have meant it to be the same thing. They rejected the argument that anticipated profits are something like a term of art, which happen, they're something that happens outside the agreement. They said, no, we have to look at this agreement and what it means in this agreement to exclude anticipated profits. And they came to the conclusion that all it meant is the money they would have received if the exclusion clause, the exclusivity clause hadn't been breached. So effectively, in these specific circumstances, there was no remedy. But what they said is, well, all sorts of circumstances could have come up here, and if the parties had meant to say something else in the agreement, they would have done, because it was heavily negotiated. Again, another one where if your exclusion clauses have suddenly become two-way, you need to make sure that that actually works and doesn't go to the heart of the agreement. And if they breach it, are we going to be able to recover our losses? And I think that's me finished. Quick canter through. Thank you, everyone.
Hi, everyone. So I'm going to be taking us on a tour of some of the key changes being proposed in the Employment Rights Bill. If we could move on to the next slide. The bill was published originally at the end of last year, and as John mentioned, it marks a really significant milestone in the evolution of employment law in the UK, and it targets a range of measures that I've summarised on this slide. The contents aren't yet finalised, but it's expected that the final form of the bill will come into force towards the end of 2026. As I said, the bill is far-reaching, and given the time that we've got available today, I'll just focus on a few key areas that employers need to be aware of and take into consideration in terms of the HR and employment practices that they're considering following in the near future. If you think that any of the proposals that we don't cover are relevant to your business and you have any questions or concerns, then please obviously do reach out to me after this webinar. Okay, next slide, please. So the first area we're going to be taking a look at is the proposed reforms to unfair dismissal protections. So the Employment Rights Bill will remove the current 2-year qualifying service requirement for unfair dismissal claims. And once the bill's in force, employees will have the right not to be unfairly dismissed from their first day of employment. Regulations are expected to set out a light touch procedure allowing dismissal during an initial period of employment, which we're commonly referring to as the statutory probationary period. And this will likely include a meeting with the employee to explain the employer's concerns. The light touch procedure is expected to apply where the termination date is no later than 3 months after the end of the statutory probationary period, provided that the notice was served during the probationary period, and that the reason for dismissal is capability, conduct, illegality, or some other substantial reason relating to the employment. The precise length of the statutory probationary period hasn't yet been confirmed, but the government's expressed a preference for it being around 9 months. Bill also proposes to introduce a special compensation regime for employees unfairly dismissed during the statutory probationary period. It's also planning to extend the time limits to bring an employment tribunal claim for unfair dismissal from the current 3 months up to 6 months. Once these changes are introduced, we are expecting, which we're expecting to be no earlier than kind of autumn 2026, it's likely that proper management of your probationary periods is going to be key, including good record keeping. So you've got that evidence to support any dispute that may later arise. Also, appraisals are going to be really essential to ensure that performance issues and any other ongoing issues are captured and dealt with early on in the relationship. For now, we're recommending that employers should consider reviewing their recruitment practices to ensure that they are appropriate and suitably robust in helping them to find the right candidates, as their flexibility to dismiss new hires is likely to be significantly curtailed once the bill's operative. Next slide, please. So we're moving on to look at the changes to statutory sick pay. So currently that's payable from day 4 of sickness absence, and employees need to be earning above a certain weekly lower earnings limit, which is currently £123. But under the new proposals, statutory sick pay is going to be payable from day 1 of sickness absence, and there'll be no minimum earnings requirement. So the changes are effectively going to mean that more employees are eligible for statutory sick pay, and it could lead to higher rates of short-term sickness absence, particularly among low earners who aren't currently entitled to statutory sick pay and therefore are currently potentially disincentivised from taking sick leave. So we're recommending that employers should consider reviewing their absence management procedures, making sure they're fit for purpose and providing training to them on their people managers, so that they can effectively manage short-term absences proactively and effectively. Next slide, please. So the bill also strengthens family-friendly rights by making statutory paternity leave and parental leave day 1 rights. So currently, we have a 26-week qualifying period for paternity leave and a 1-year qualifying period for parental leave. Those will be removed. Further changes being made to remove the current restriction on taking paternity leave and receiving statutory paternity pay following a period of shared parental leave and pay. In addition, the existing right to 2 weeks parental bereavement leave following the death of a child under 18 or a stillbirth is likely to be extended to an entitlement to more general bereavement leave, which will apply to the loss of a wider group of persons. Regulations are going to specify which relationships with a person who's died will qualify, but we're waiting for further detail on that. So it's not quite known yet what the extent of that extension is going to be. A new provision on given the right to leave after miscarriage looks likely to be introduced, and it's proposed that this would give mothers and their partners the right to 2 weeks of leave if they suffer a pregnancy loss before 24 weeks of the pregnancy. In terms of practical tips for employers in relation to all of these measures, we'd recommend that you start looking at reviewing your existing policies or introducing new policies that address each of these points, and also making sure that you follow up by training your staff on these policies so that there's an awareness in the business. You can also consider whether you want to enhance the basic statutory entitlements, which are there as a minimum. You're not obliged to offer enhancements, but it's something that some employers do find helps them with potential recruitment issues. Next slide, please. So next up are the proposed changes to the dismissal and re-engagement process, which is commonly referred to as fire and rehire. So fire and rehire is a method of imposing changes to contracts where the employee doesn't agree to the proposed change. Following a consultation process, employee is dismissed on notice from their current contract and then immediately rehired on the new contractual terms. This practice, you may have heard of it, it's considered controversial and has received quite a bit of negative press in recent years. It's because the threat of dismissal is used to force through the changes to contract, and that sort of highlights the imbalanced power dynamic at play between the employee and the employer. It's the government's intention to severely restrict an employer's ability to use this practice by making any dismissal automatically unfair, where the reason for the dismissal is that the employee didn't agree to the employer's attempt to vary their terms, or because the employer intended to employ another person on varied terms to carry out substantially the same role. A narrow exception will apply where a business is facing financial difficulties that threaten its viability, and the need to change terms is unavoidable in those circumstances. But in those circumstances of that narrow exception, an updated code of practice, which hasn't yet been published, will apply. So again, we don't have the full details there yet. Having strong relations with your workforce is likely to be increasingly important if these measures are introduced, because unless you're prepared to risk facing litigation and potential bad press, you're going to need to obtain consent to make changes to contracts. So positive relations and ability to justify the changes that you're proposing to make and convince employees of why they need to agree is going to be really crucial. On to the next slide, please. So I'll just run through some provisions in relation to harassment quite quickly. Towards the end of last year, in October 2024, new rules came into force that you might have heard about, where employers are required to take reasonable steps to prevent sexual harassment of their employees. The Employment Rights Bill proposes to take this a step further and impose an obligation on employers to take all reasonable steps to prevent the sexual harassment in their workplace. So employers will also be under a duty to take all reasonable steps to prevent third-party sexual harassment as well, and also to prevent third-party harassment in relation to relevant protected characteristics under the Equality Act, so things like disability, age, race, gender. If these measures are brought into force, it will become much harder to successfully defend harassment claims, and you could face both the financial penalty of compensation and a potential investigation by the Equality and Human Rights Commission that could result in enforcement action. In addition, the bill makes it clear that making a report that sexual harassment has occurred or is occurring or is likely to occur or will be a protected characteristic for whistleblowing purposes. So that means that workers who make whistleblowing disclosures about that will be protected from suffering a detriment as a result. And the dismissal of employees will be automatically unfair if this protected disclosure is the motivation for the dismissal. This change may impact how you investigate sexual harassment complaints, which will in the future fall within the scope of your whistleblowing policies. So what we'd recommend again is reviewing your policies and ensuring that your staff are adequately and regularly trained on the topic to make sure that you're doing all you can to take all the reasonable steps to prevent sexual harassment. Next slide, please. Okay, so moving on to look at the terms intended to address insecurity in terms of hours. The bill requires employers to make an offer of guaranteed hours to qualifying workers based on the hours that they regularly worked over a defined reference period, which is likely to be a 12-week period but hasn't yet been confirmed. Employers have to offer a new or varied contract that reflects the hours worked during that period. There's no obligation for the worker to accept those offers of guaranteed hours, but it does look like employers are going to be obliged to keep making offers at the end of each subsequent reference period. So potentially every 12 weeks they'd have to make a further offer. It's important to note that it will be automatically unfair to dismiss an employee if the reason or the principal reason for that dismissal is that they accepted or rejected or proposed to accept or reject a guaranteed hours offer, or where the employer sought to avoid compliance with its duty to offer guaranteed hours. Employers will also be required to give reasonable notice of shifts and changes to shifts, but the government are yet to consult on what this will look like. It's clear that workers will be entitled to compensation if their shift is cancelled, moved or curtailed at short notice. And workers will have a right not to be subjected to a detriment by their employer on the grounds that related to an offer of guaranteed hours, rights to reasonable notice of shifts or compensation for cancelled, moved or curtailed shifts. And it's important to note that these provisions are going to also apply to agency workers to prevent employers from avoiding these obligations by staffing their business using agency workers. And it's the end hirer, so the end business, that will have the most liability for those obligations in relation to agency workers. Final area I'm going to take a look at is in relation to redundancy and reorganisations. So here we've got currently, in terms of collective consultation, which you might be familiar with, where an employer is proposing 20 or more redundancies at one establishment, within a 90-day period, they have to go through a collective redundancy consultation, which basically means they have to liaise with employee representatives for a defined period. Establishment in this context essentially means a site or workplace. And what the bill introduces is a new concept of a threshold test that will involve counting employees across all sites or workplaces when deciding if the trigger for collective consultation has been reached, which waters down the site-by-site approach that's currently in place. Those thresholds haven't been clarified in terms of the detail yet. So again, we're just waiting for that. But the bill does also propose to increase the maximum compensation that's awarded where collective consultation obligations are breached, increasing it from 90 days pay, which it currently is, to 180 days pay. So it can be an expensive one to get wrong. There's also a change proposed that will affect business transfers and outsourcing arrangements. Currently, private sector employees and ex-public sector employees can end up working on different terms and conditions in the same business following the transfer of a public contract. So the government's concerned that this creates a two-tier workforce, and the bill seeks to introduce new powers to avoid this. So regulations might require public outsourcing contracts to include terms that any workers transferring from the public sector should be treated no less favourably than when they were employed in the public sector. And private sector employee workers working for a supplier will need to be treated no less favourably than the ex-public sector workers who've transferred to that business. So potentially quite a key one, because if implemented, this will need to be considered by employers working in sectors where they're going to take on public sector contracts. As careful due diligence and planning is going to be needed to establish the future liabilities, not only to any transferring staff, but also the employer's existing staff. So onto the next slide, the final slide. So in conclusion, that was a quick tour around some of the key changes proposed by the bill, but it's worth noting that the amendments are likely to be made as it passes through Parliament. There are also some areas where further consultation is required, or we're waiting for supporting regulations to be published. Due to time, I've only focused on a few key areas that will change under the bill, but the provisions are extensive, and there are other key areas that are subject to change, such as the introduction of a Fair Work Agency that will have enforcement powers, measures to regulate the use of umbrella companies, and also collective rights and trade union relations terms. We're going to be running more detailed focus sessions on the bill as it develops. So if that's something that you're interested in, please do get in touch. So I'll hand it back to John now, who'll round off the session for us.
Thank you, Sophie, for a really helpful summary of what is going to be, I know, a very significant piece of legislation. And as Sophie said, her and her After Athena colleagues will be providing ample further advice on this as we progress. Big thank you also to Rachel for what was again a very helpful summary of some of the latest updates in contract law. We've covered a lot of ground. I don't think there are any questions that I see unanswered in the chat. Although please, if there is anything, please don't hesitate just to let us know. Yeah, I see someone's dashing, but they're thanking us. So if there are any questions, please let us know, and we will answer you directly. As I say, much more to come from After Athena on the Employment Rights Act, much more to come from Napthens on the Data Use and Access Bill, and we very much look forward to joining you again in approximately 3 months' time at the latest to pick up on that and on further issues, and look forward to speaking to you then. Thank you for joining us.